عشان هيك يا جماعة بنقول إنه كلمة أو عبارة أو the phrase of the other inhuman act would only include the act which has the same kind, the same character as the other mentioned categories of conducts that are mentioned in Article 7 from A to J. That's why we or some jurists of criminal law considers that the Article K here, or the Article 7.1K, is not against the principle of the legality of crimes and penalties. If you need another example for the use of such kind of interpretation, I mean the iusdom generis, you would find this decision which is made by the pre-trial or from the appeals chamber in the extraordinary chambers in the courts of Cambodia. You will find in paragraph 160 it is mentioned explicitly here in the article, the paragraph 160. Let's move to paragraph 160. You will find the court depends on this kind of interpretation and its decision. So here, look, it says the pre-trial chamber finds that when looking at the plane of meaning of other inhuman acts, there is a statute which is applied in Cambodia, and it contains or it includes the word other inhuman acts. So the court here is talking about such phrasing, and it says that the pre-trial chamber finds that but when looking at the plane of meaning other human acts, the word other here imports an ius generis rule of interpretation. لاحظ ايش اعتمدت في التفسير على كلمة لكلمة other، اعتمدت على قاعدة التفسير من نفس النوع whereby this category can only include acts which are inhuman in the sense that they are of a similar nature and gravity to those specifically enumerated, namely murder, extermination, enslavement and deportation. اوكي؟ فهذا اللي احنا قصدناه بانه بعض الفقه بيعتبر انه هذا مش خروج على مبدأ شرعية الجرائم والعقوبات، وإنما هو تطبيق له. فطالما أنه النص وضع ضوابط معينة وحط لنا كلمة يمكن من خلالها أن نخرج من هذا المأزق فلا بأس. يعني لما بيجي المشرع يقول لي other inhuman acts ويسكت، هذه مشكلة، لكن لما يجي يقول لي of a similar character معناته نحن دخلنا في نطاق ما يسمى use generis legal interpretation. أوكي؟ فحبيت أوضح هذه النقطة. في كل الأحوال، أول الضوابط الملقاة على عاتق المشرع الدستوري عندما يتعامل مع وضع النصوص الدستورية، فإنه يجب أن يكون مقيد بوضع نصوص تشريعية قاطعة الدلالة ونصوص حاسمة في التجريم. أوكي؟ يعني لازم يكون السلوك منضبط ومعروف إيش هو السلوك اللي أنا بجرمه. إذن هذه أول ضابط يلقى على عاتق legislative authority according to the legality principle. Number 2, no delegation shall be granted to the executive authority regarding incriminating and penalizing process unless otherwise provided in the constitution. واللي ممنوع انه اي سلطة تانية تتولى عملية التجريم. يعني مثلا السلطة التنفيذية ليس بيدها ان تضع نصوصا تجريمية ونصوصا عقابية الا اذا كان مين بيسمح بذلك، إذا كان في نص في الدستور يسمح بمثل هذا النوع من delegation. So this paragraph wants to deliver an idea that the legislature is the only organ. It is the exclusive organ which has an exclusive also authority to put the criminal text regarding the incrimination and the penalizing. Okay? So if there is a way to make kind of delegation, and this delegation is authorized by the constitution itself, then it's okay. However, if there is no text within the constitution which allows such delegation, then it would lead to a null criminal text if they are made by the executive authority. Well, the legality principle, it puts an obligation on the shoulder of the legislative authority. It says the criminal texts must be applied to the crimes occurred after their adoption. So if the criminal text was made, for example, in 2019, then this criminal text shall apply to people who commit the crime which is mentioned in the criminal text if they commit it after this criminal text was promulgated, after 2019. So it mustn't be applied to those who committed crimes before the made of or the creation of the article or the criminal text, okay, unless they are better for the sake of the criminal, and this will be discussed later inshallah. We will know how can the criminal text be applied in a retroactive way. كيف ممكن ينطبق القانون العقابي أو النص الجزائي بأثر رجعي، ممكن أنه ينطبق بأثر رجعي إذا كان طبعا أصلح للمتهم، وهذا كلام راح نشوفه لاحقا إن شاء الله. The penalties have to be clear and specific. حتى العقوبات يا جماعة زيها زي النصوص التشريعية المتعلقة بالجرائم، لازم تكون العقوبة أيضا clear and specific. So if there is a criminal text, for example, the crime is mentioned, however the penalty is not mentioned, in this case the text would be considered as if it is not existed, so we mustn't deal with it. It is like we must consider it as if there is no a criminal text, okay. So the penalties are important as the crimes, so the penalties have to be clear cut, they have to be specific also, okay. So these are the limitations, these are the obligations of the legislative authority according to the legality principle, okay. Now also we do have the obligations of the judicial authority according to the legality principle. Well, number one, the judge has to exonerate معناته يبرئ. It's like exculpate, the same meaning, exculpate or exonerate, the same. So the judge has to exonerate the accused if there is no criminal text applied to his deeds, even if these deeds are so horrible. القاضي مش ممكن يوقع عقوبة على شخص إلا إذا كان في نص تجريمي بجرم الفعل وبحدد العقوبة، حتى لو كان الفعل اللي قام فيه وجاء من أجله المحكمة فعلا مشينا، طالما إنه ما فيش نص بجرم هذا الفعل بيقدرش القاضي إنه يقوم بإنزال العقوبة فيه أو حتى محاكمته ببساطة because there is no criminal text applied to his deeds. So even if the deeds are so horrible and so hard to be accepted by the community, the judge has nothing to do in this case. The judge cannot work without a legal text which criminalizes the act and which puts a penalty for such act. Also, the judge shall apply the criminal text on words unless it is better for the sake of the accused, and this is what we will discuss later inshallah. It means أنه القاضي يجب أن يطبق النصوص الجزائية بأثر فوري ما لم يتبين بأنه وطبعا في استثناء على هذا الأمر، أنه تطبيق القاعدة الجزائية اللي بتكون أصلح المتهم، وهذا إشي راح نتكلم عنه لاحقا في موضوع مهم جدا. And finally here the judge shall apply penalties according to the criminal texts, so no higher than the max limit or less than the minimum limits unless otherwise provided. I put D here, which is called the judge discretion. So every crime or every penalty has two limits, the max limit and the minimum limit, but the judge cannot give a penalty which is higher than the max nor less than the minimum unless he is provided with a discretion in the legal text itself, and we will discuss this inshallah later. To this end I end my lecture and see you inshallah in the coming lectures inshallah in the near future. Thank you dear students.